This is CJ Holmes, founder of Homeowners for Justice, and welcome to Weekdays Live. Today we've got breaking news. I'm telling you, every day something else is happening, and it's really pretty interesting, and that's why I want to bring this to you every day. We've got Linda Zimmerman on with us, and before we talk about how we're going to fight back with securitization, and we've got Joe Esquivel, a securitization specialist, on the phone, ready to share with us a tremendous amount of information. But Linda, help us understand what you've just discovered about more fraud and conspiracy on the part of the banks and foreclosure trustee mills.
Okay, thank you. Good morning. In my own fight and in assisting others to be registered on the programs to the National Mortgage Settlement the agreement that took place, when I'm calling in for people and even for myself, and I knew that these people qualified, we're getting told by the entities there that no, they don't qualify. And I said, why not? They said, not only in the case of judicial states like Florida, the foreclosure had to have been ordered or the judgment entered, but the sale had to take place. This opened up a can of worms because I remember after the judgment, all of a sudden, mysteriously, J.P. Morgan Chase started filing cancellation of the sales, one after the other. And I sat in the courtroom as they're going through person after person canceling the sales, walking out to the next room, rescheduling, and thought maybe something we did was working. And their cover to the judge was they were checking their documents in the light of the robo-signers. Well, it turned out that the vast majority, and there were 22 that day, who were rescheduled, then were sold in 2012, which made them ineligible for the mortgage settlement. And I think this is a trend. I think if we search more, and I'd like anybody who was foreclosed on in that time frame, 2008 to 2011, and that the sale didn't take place till 2012 to contact me because I'm gathering a report for the Department of Justice, and I'm going to report this new fraud that they've
intentionally, they knew coming down the pike what the rules are going to be, and so then they've intentionally changed what they did so that they would benefit and hurt more homeowners.
Absolutely. And their statement that they checked the files for inaccuracies, I'm currently in appeal on the state level, and they didn't check my files. In fact, they probably got worse because I see that I knew that there was a certain order that my file was placed into the literal file, and I can tell by the marks that my file has been altered by the punch hole marks because the papers were staggered, and all of a sudden they're in beautiful unison, and there's no punch hole marks. So they've substituted the documents and put in a completely different file. And I think in the deed of trust states we'll find the same thing. So, if there was a delay in your sale, that should have happened, check. And I think we can get together a database and go after them.
Well, this is no surprise. And thank you so much, Linda, for sharing. I want to go back to, just before we have Joe join us, I've pulled some more documents and recordings. These are all on Stealing Your Home on that page on my website. But we understand that the government has abandoned us. And this is what we heard William K. Black say so bluntly. It's up to the people because the officials have been bought off and they are not going to make the changes. That is, they're not going to protect us. We're on our own. And so we must organize and we must get everybody in the country to join us because first off, there's more boots of us than there are of them. There's more people. But secondly, to get our justice back as justice in our court system, we must join together. Now here, just some things I want to point out real briefly, and then we're going to jump into the securitization and get some of our questions asked about why is that so important in fighting back against fraud. Because you got to understand, fraud is a fabulous business model, and the banks have been fraudulently generating the toxic mortgages, foreclosing fraud closures with fraud to foreclose. Now they're over into derivatives. I've got here a quick article. The FDIC now Remember, I said yesterday, that was one of the clips. We, the taxpayer, the Federal Reserve has dumped onto the FDIC to cover the $75 trillion Bank of America derivative bets. And as we talked about yesterday, just briefly, the derivatives now at 750 trillion, when the GDP of the whole planet is only 65 trillion. We're the US, that's just by 4 banks, and we're on the hook for that. Or I think anyway, it's just outrageous. It's completely stupid, and it will break the system. That's why we have to get there first and fix the system so that we aren't broken. This is just outrageous. Here's the Timothy Geithner, who actually is quoted now saying that solving the housing crisis just was not possible. And I want to point out to you that in this article, Cautious Moves on Foreclosures Haunting Obama, this was written in August 19, 2012. I want to scroll down the article, and you'll notice that it talks about, let them eat carrots. How far does $1 trillion go? And this is what I want to point out. It says right here, Mr. Geithner told Mr. Obama that even if an additional $100 billion were available, he would not spend it on housing. We must understand, we do not have any friends. Don't expect the government, anyone, Bernanke, Geithner, Obama, Holder, he's a longtime bank attorney. Don't expect anything other than bank support out of the heads of government. We must get back to basics and get back down to the local level. We're going to have some clout there. And I just quickly wanted to point out I've got a defense page. It's this is notary fraud and forgery. These are forged documents and signatures, and I've linked here William K. Black's testimony so you can look at it again, and the list of 59 frauds an attorney that fights foreclosures on behalf of homeowners has to fight when he goes against the banks. It's pretty amazing what this list is. And then down at the bottom, of course, I've highlighted O'Brien's 20 signatures of Linda Green that they found on their documents. This is why they are convinced they are forged. And then down here is a list of names with forgeries of, these are recorded documents people have sent me or I have gotten with these people's signatures on them, the same name but different signatures. So check down the list, see if any of them are on your documents. If they are, send them to me. If you have documents you want me to collect on that signature, send them to me. The fact is, a lot of these you can Google on Google yourself, and you can find different signatures. And I'm trying to get a legal opinion to see if this is enough to take to our district attorneys and our recorders and our supervisors and get them to support, for example, an affidavit of authority at the recorder level. So behind the scenes, we're working on all of that, trying to come up with solutions that will work for the people. And here, just for a quick example, and then we're going to move on with Joe. This is Randall Rays. He's an attorney, defense attorney against fraud closures for owners, and this is his list of frauds, and you can read down them and perhaps send this list to the people that you know. Falsely claiming to be the holder of the mortgage, falsely claiming standing by use of names such as trustee, assignee, nominee, beneficiary. In other words, they fake these names. It's not just the signatures, it's the titles that they have faked, and fraudulently invoking the jurisdiction of the court, preying on the ignorance of the court and the homeowner, falsely claiming pooling and servicing agreements, industry standards, rules, guidelines, or other industry authored writings that supersede the law. And the judges are still judging for them, and the owners need to fight back. We need to stop this fraud. So this is information available to you on my website. Don't hesitate to use it. I've actually got a couple of other new pages, corrupt officials, judge corruption, and I've hooked as many things as I can from Joe that we've got today. He just sent me another 15 documents, I think, that I will upload after the show, and I will put them on the tangible, intangible, because this is all about securitization. When they take a tangible property and a tangible note, and then they strip the payment stream out of that note, making it basically worthless, because who would want the note without the payment stream? And then securitizing that payment stream and selling that on the market. This is the basis of the derivatives. This is why there's a rolling crisis of fraud. This is why foreclosure fraud is just one fraud in the river of fraud that the banks are now perpetrating on the people. So with that, I'd like to bring Joe on board. Hey Joe, this is CJ. Thanks for joining us today. Can you give us a little bit about yourself?
Sure. My name is Joe Esquivel, and I'm with Mortgage Compliance Investigators, and I'm a mortgage securitization analyst, and I do analysis. I do chain of title analysis.
And Joe, why is that important?
That's important because there's more than one instrument involved, and we need to have a complete chain of title that matches the chain of endorsements or chain of ownership.
And so what you're trying, correct me if I'm wrong, because I'm just trying to put in lay terms how this works. So you're saying the people in fighting back against this fraud need to know what happened at the securitization side and try to match that with what happened at the physical side, the tangible side.
Correct. The events that were to happen in parallel.
Right.
So, when the note was physically sold, at the same time and in parallel, there would be an assignment of the security instrument, and it would have been recorded at the county recorder's office, giving constructive notice to the world. So if we start from the very beginning, okay, so you're at title, and you're at the closing, and you sign the instruments, okay?
Right, you sign the loan.
You sign the loan documents, okay? After signing, the title company sends a security instrument to the county recorder's office, all right? And there it is recorded, all right? Sends the note to the lender, okay? Now, once the county recorder office records it, they send their documents back to the lender.
Right.
Now, if you were with a GSE, and a GSE would be a government-sponsored enterprise, such as Fannie Mae, Freddie Mac, Ginnie Mae, all right?
Right.
Documents would travel a little different route than if your loan was sold into an RMBS or an AMBS. An RMBS would be a residential mortgage-backed security.
Okay.
An ABS would be an asset-backed security.
Now, before you continue, I know you sent me all these documents, and you also earlier sent me these highlighted prospectus. Let's not forget to talk about that. How does that tie into these other charts that you sent?
Okay. What I sent you were updated charts that I've authored and researched. And basically, because I write my analysis in legalese, and I've had people ask me, Joe, I don't understand all these legal jumbo. I don't understand what you're talking about in regards to the UCC. So what these charts do is they show in one page what I've written in 30 pages.
Okay.
So if you'd like to pull one up, we can, if you want to pull up, say, a Fannie Mae using MERS.
Okay, here's a Fannie Mae using MERS. And for the viewers, I will get this uploaded on the website after the show, so you can just click on the link. Here we go. Okay, it's up.
Okay. So, all right, so we'll start from the top. Now, one of the things you have to understand is Fannie Mae, Freddie Mac, and Ginnie Mae all put out documentation stating what is to be done. So everything that is on the chart is as per Fannie Mae documents. So nothing is made up, and it's done simplistically so that even a layperson can understand what's going on. So we're going to start at the top, and it says borrower, signed at closing in the upper left-hand corner. Okay?
Right.
So John Doe signs a note. All right? Now, when they sign the note and the security instrument, all right, the security instrument is in gray. The security instrument can be either a mortgage,
right,
or a deed of trust, or if you're in Georgia, it can be a security deed.
Okay.
All right? There's two separate documents. The note is a promise to pay, and your security instrument is a separate contract evidencing the conditions in which to collect payment in the event of a default.
Right. It makes the house the collateral for the loan.
Correct. It lists the conditions to enforce.
Got it.
So now the security instrument is sent to the county recorder's office, and it's recorded.
Right.
Okay?
Right.
Now, it's then sent back to the originator. Okay? In this case, it's Countrywide Home Loans.
Got it.
Okay. Now, when the lender gets it, we now have a perfection. All right? It's been perfected. It's been recorded. We've given constructive notice to the world. All right? So now the note is secured by the security instrument. Okay?
Yes.
Within 24 to 48 hours after Countrywide gets the documents, the note is scanned into their system. Okay?
Right. Right.
If anybody has access to the Linda DiMartini deposition in Kemp versus Countrywide, you know, they state what Countrywide does.
Right.
All right? So once it is scanned into the system, all right, another 24 to 48 hours after that, an endorsement in blank, paid to the order of without recourse, is stamped onto the documents, the physical document. Those documents are then sent to the warehouse, and they stay there. All right? Now,
Okay.
the payment intangible obligation we're going to talk about, which is the right to collect future payments. That is your promise to pay. I promise to pay Countrywide Home Loans 360 payments starting in the year 2000 to the year 2030. Okay, that is your promise.
Right.
That promise is sold. In this case, it was sold to Fannie Mae. Okay?
Right.
So that is called the intangible payment obligation. It's stripped
Right.
and transferred electronically.
Right.
All right?
Right.
Now, once that happens, all right, because they have not sold the physical note.
Oh, okay, okay.
What they've done is a transfer of rights.
Exactly.
Now, that transfer of rights would fall under UCC 3203, D as in dog. All right?
Right.
Because they only transferred the obligation. If we were to go to the statutes, it says if a transfer purports to transfer less than the entire instrument, negotiation of the instrument does not occur. The transferee obtains no rights under this division and has only the rights of a partial assignee.
Okay.
So what's happened is that, yes, they have sold the payment obligation, the intangible. That's true and correct. However, the note, the paper tangible note, is no longer eligible for negotiation.
And what does that actually mean? What does that mean in practical terms?
That means is that the instrument being the note, the security instrument, and principal and interest should have all been transferred, should have been sold together as one. Normally, if you go back 30 years, what would happen is that the bank would sell the note, the bank would perfect the note by recording into public with the new payee, all right, and then once that note had been perfected, they would then sell that to a trust.
But they would sell the payment stream and the note, not just the
Correct.
payment
You would-
stream.
Not just the payment obligation. In many cases today, these trusts are made up, these trusts are created prior to many of these loans even taking place.
Right.
So, once that payment intangible obligation is sold to Fannie Mae, okay, in this case it would be Countrywide. Countrywide is now the account debtor.
Because they sold the payment stream to Fannie Mae, and so they're on the hook for that.
Correct. Countrywide is the account debtor.
Got it.
Countrywide is a creator of the intangible payment obligation, which is backed by the payment stream of the tangible note.
Right. Okay.
Okay, now, Fannie Mae is the intangible obligor, or obligee, I apologize. Fannie Mae is the intangible obligee. Okay?
Right, they're getting the
However,
payments. Yes.
upon receiving this intangible payment obligation, all right, what they do is they create a second intangible obligation, and it's pledged as collateral to the certificate holders, whom are the investors in this Fannie Mae trust.
Oh my goodness.
So if you look at the arrows, okay, it's actually pretty simple. The arrows show the payment intangible obligation coming out,
Yes.
okay, and then it shows going down to Fannie Mae, and then it shows a second intangible obligation is created by Fannie Mae, and then the payment obligation goes into the Fannie Mae certificates.
Right. Right.
And now, every time there's a transaction, the transaction is sent to MERS, Mortgage Electronic Registration Systems.
And basically that means a member of MERS logs in and logs the transaction.
Correct. And again, MERS is a database. They only operate in the intangible world. They cannot operate in the tangible world, even though they would lead one to think that they were operating in the intangible world. They cannot. Because these are all electronic documents, all right? You cannot use real property law, you know.
Right. Right. Because we've talked about the different... Go ahead.
Correct. Even though they're trying to use electronic signatures and such, you have to understand, under 15 U.S.C. 7003, e-sign and UE edit do not apply to Article 3 or Article 9. Now, the payment intangible obligations can be stripped and sold all day long under Article 9. That is no problem. That's legal. You can do that. This is how they're able to have one special purpose vehicle for the investors and have all different types of investors. Because let's say you have 10 classes in a trust, and I've seen them with as many as 85 classes.
And just a minute, Joe, what's a class?
A class or a tranche. When we show Bloomberg screenshots, we show the number of classes that are in a trust.
Okay, and those, basically each class has a different risk and interest, right?
Right.
Okay.
The amount of risk determines what class you're in.
And this was all made up by the person that sets up the trust.
Correct.
Okay.
And if you were in an RMBS, when they set up that RMIC, all right, they would file with the SEC, all right, and the IRS. And for the IRS, it'd be published in IRS Publication 938. Now, the reason they're required to file this is because under the 1933 Securities Act, which came into play after the Depression, this was a requirement. So they must list all of the classes.
Okay.
So depending on the risk of loss is what class you would go in. And this is legal if done correctly.
Right. Now, what was incorrect in this?
Well, what was incorrect is that the note was never sold to the tangible promissory note was never sold to Fannie Mae as a payee.
Okay, they just sold the payment obligation.
That's all they sell. Fannie Mae is not listed as beneficiary for the security instrument. They have never been recorded. They have never been assigned a beneficial interest. They have not been listed as mortgagee.
Right.
So they've given no constructive notice to the world that they play a role in this loan. So even though when someone has a Fannie Mae loan, and what happens is that the servicer is assigned the security a beneficial interest in the security instrument. Now, one would think if one were assigned a beneficial interest in a security instrument, that they would have already been transferred and endorsed and negotiated the negotiable instrument as well, being the note. And that does not happen.
And that should have happened at the time instead of stripping the payment obligation. If they had sold the note to Fannie Mae, then they would have at that time had their beneficial interest assigned.
Right, but you have to understand. I mean, right now, if everybody were to get out anyone, 90% of the documents that are put out today, all right, are done in a Freddie Fannie multi-state form.
Right.
Depending on what state you're in would depend what instrument you would choose. So if you're in California, your security instrument would be a mortgage. And if you were to go to Covenant 20, in Covenant 20, your security instrument reads, this note or a partial interest of the note may be sold together with the security instrument. Now, right there, it tells their intent. The note or a partial interest may be sold together with the security instrument. So we know what their intention was. And by them recording the security instrument into public at the county recorder's office, all right, we now have prima facie evidence of what they wanted to do. And selling of the payment intangible obligation, all right, shows what they did. All right, we have Bloomberg screenshots where we can show, all right, here's the payment intangible obligation. All right, this is where it is.
Right.
Of that trust was done prior to the selling of the payment intangible, prior to any negotiation of the note which should have taken place.
Right. And so because they basically never assigned that security instrument and note to Fannie Mae, or in this case.
Right, you don't assign the note. You negotiate and transfer the note.
Transfer it. Okay. Would they? So how would they have done the security instrument? What should they have done there with that deed of trust or mortgage?
Security instrument, they should have. One moment. My throat's a little dry.
Oh, sorry.
So upon selling of the tangible promissory note, all right, the party A would have released any rights that it had in the security instrument, and it would have assigned those rights to the party that they were selling the note to.
So that would have been an assignment of the deed of trust, let's say, from Countrywide to Fannie Mae.
To Fannie Mae.
At the time.
They would have then recorded this
Right.
on
At
a
that
recorder's
time.
office, thus giving constructive notice to the world and perfecting the note.
Right.
It would have been in the name, paid to the order of Federal National Mortgage Association.
And it would have been at that
A note.
time. Right, not years later.
Correct.
Right.
Once Humpty Dumpty has fallen off the wall, cannot put them back together
Right. Except they're doing that. They're doing that all the time.
to do it.
So how do we fight back?
Well, one, because Fannie Mae is not listed as beneficiary or mortgagee, one, you need to stop. This is why when we do the analysis, I say what was to happen, what did happen, and then what did not happen, and then we use these charts to reference the analysis. So what you don't see on this chart is that I have text boxes that reference specific paragraphs within the analysis. So when you're looking at this chart and it says, okay, see paragraph 17, then
Right.
you go to paragraph 17 of the chart and it explains that area.
Right.
So even though, you know, things are being done that you don't possibly understand, that the analysis paragraphs can explain in the chart, and the same thing in certain paragraphs of the analysis, I reference the chart. So you can look at one, pull up the chart, look, okay, now I see what's done.
And so basically when Fannie Mae claims they own this property and they foreclose on it, and when a buyer goes to buy it, they have to buy it from Fannie Mae. They've actually just made up all those foreclosure documents to say Fannie Mae owned it?
What they're doing, again, it says Fannie Mae owns your loan. Nobody has ever questioned. All right? So if Fannie Mae says, we own your loan, okay, I need you to be more specific. What is it that Fannie Mae has acquired? Fannie Mae has acquired the payment intangible obligation. All right?
Right.
While that payment intangible obligation, all right, was to be secured by the intangible payment stream of the tangible note, all right, that intangible obligation was created by the account debtor. So the
Countrywide.
debt runs to the account debtor.
Countrywide.
Correct.
B of A now.
Not run to the borrower. All right. Fannie Mae was never recorded into public as beneficiary.
Right.
So this is why the investors, all right, they don't sue the homeowner.
Right.
They're going to sue Fannie Mae. Fannie Mae then, all right, would then sue the originator. The problem is that many times Countrywide or Bank of America right now, because Bank of America is successor to Countrywide Financial, a successor in interest. So Bank of America is the servicer. So Bank of America is acting as agent for Fannie Mae. Bank of America is not going to sue themselves. Bank of America is going to say, we are going to sue the borrower of the tangible note, even though they are not a party to this intangible obligation, which was created by Countrywide Home Loans.
And basically they just do this and have been getting away with it.
Yes, they've been getting away with it because no one has contradicted what they've said.
Or
McGuire has written about this for the last 10 years.
Or-
People just need to read, understand.
Well, and I've heard from so many people that even if they do contradict it, the judge rules for the bank anyway.
Well, the arguments, truthfully, have not been correctly brought up to the judge. And that is the problem. If you don't bring the correct argument, they can only rule on what's brought forth. You know, we've had some bad case law here in Nevada, and the reason it was bad because you went to a gunfight with a knife and you got your butt kicked.
Right.
So if you go with the correct arguments, okay, I mean, this is why, bankruptcy works in many situations.
And why would you say that? Why does that work better?
Well, I'm going to speak, again, I'm not giving legal advice. I'm not an attorney, so nothing is to be construed as legal advice or opinion. But I can tell you for myself, okay, because many of these loans are unsecured, and you can discharge unsecured debt, all right, the question is what to do after you've discharged the debt.
And so you go into bankruptcy court with the payment stream obligation as unsecured debt?
Correct.
And then it gets discharged.
Right. Again, I'm not telling anybody what to do. I'm just telling you in my particular case what was done.
And I'm just trying to understand how this actually is currently working and how we might be able to, shift the perception and it to the owners. The owners need help. They want to keep their houses.
Right. Let's go back to one of the things in bankruptcy, okay, is you've got what's called the bankruptcy 362 rule, which is an automatic stay. So the minute a bankruptcy is filed, all right, all actions that were concerning collection of a debt have to stop.
Right.
All right. One cannot perfect or create, all right, a perfection of a debt, all right, once BK is filed. Now, you also have what's called the BK 3001 subsection D rule. So that's 3001 subsection D as in dog. And what that says is evidence of perfection, security interest. All right? If a security interest is claimed, the proof of claim shall be accompanied by evidence that the security interest has been perfected. Well, let's see. Let's go back in the public record and let's check to see what the public record says. For John Doe, it shows that the deed of trust is still with Countrywide.
Right, not with Fannie Mae.
Fannie Mae is claiming to own the loan.
Right, right.
So now we have, a dispute.
Yes.
So if Fannie Mae cannot come forth with evidence of perfection of a security interest, all right, then it's not secured. It's an unsecured loan.
Interesting. Okay.
So, again, this is just what has happened to me personally.
Right.
So we're not just saying anybody to do anything. I'm just telling you this is what, in my case.
Right.
So I was able to prove that my debt was not secured.
Right. In court.
Such it was discharged.
Right. And so basically, I'm assuming in your case, did you have a foreclosure auction facing you?
No.
Okay.
No. And in my case, I lost a business, and I was attempting to negotiate with Bank of America.
Right.
8 months prior to that, while we had a viable business, upon negotiating with Bank of America, they had raised my payment because due to the amount of income that I was making at that time, they said, well, we're going to adjust your payments to 33.33% of what you make.
Oh, God.
And I said, fine. But then when I lost my business 6 months later and I went back to Bank of America,
right,
and I asked them, listen, based on what we did last time, I'd like you to lower my payment. And they just said, no dice.
Exactly.
Foreclose.
Exactly. And this is one of the frauds, many frauds that are listed that attorneys are having to fight to help people against foreclosure. And that is the fact that they literally just make up the rules as they go and get away with it. And they can allow or disallow payments and loans, and it's truly outrageous. And the people don't have much recourse. This is one of the dilemmas, but this helping us understand the fact that the security instrument, and see, I see this all the time. This is the notice of default, and people will say, help me, help me. So I'll look at their notice of default and look at assignments that are on their file, and there's never any assignment to anybody that's trying to foreclose at the time of the loan was made. So basically, this security instrument, this deed of trust, should have, in this case, should have been assigned to, and the whole note sold to Fannie Mae at that time, like in 2006, whenever that loan was made.
Correct.
Yes.
Correct. So what should have happened is that the note should have been endorsed to Federal National Mortgage Association.
Right.
And at that time, and in parallel, there would have done an assignment, okay, of the security instrument to Federal National Mortgage Association and recorded that into public, okay, and then we would have had a perfection and an attachment of the security instrument to the debt.
Right.
The problem was that when the debt was sold, which can be done, day after day, a good example of this is if you have a strip shopping center, and let's say you've got 10 stores, all right? Now, you own the building, and you're leasing all of these stores, so that is your income, all right? Now,
right.
You get behind and you've got a lot of bills. What you could do was sell the leases for those 10 stores.
Right, we call that factoring.
Done for the note, and it's legal.
Right, yeah, factoring. People can factor. Go ahead.
Correct. So they sell the payment intangible obligation under UCC Article 9.
Right. But
because that is what is valuable. The problem is that because you sell that payment intangible obligation, you've reduced the value of the security instrument.
That's right.
Well, now the tangible note is a worthless piece of paper, and there is no debt to evidence
right
conditions in which to collect.
Right. And just in that example that you used, and I think that's a great example because it really makes it easier for me to understand too. When a building owner sells, the payment obligation, but does not assign that security instrument to go with it, then when any of that payment defaults, the buyer of that goes back to the building owner. They're the account debtor. Right. They're on the hook for that.
Right. So, in this case, Countrywide is the creator of the intangible obligation.
Right.
They're the account debtor. Now, yes, they wear many hats, okay? And that's true. But they sit on the fence of the tangible and the intangible.
Right. Right. Now B of A now has probably by merger or whatever they're going to claim, they now have taken over those servicer rights from Countrywide.
That's fine. What you have to understand is that they make their money through fees. All right? So if there's 35 classes in a trust, all right, and there were 35 different investors, they're charging each investor a fee.
Right.
Their money in these fees.
Of course they are. Right.
So they're just an agent. That's all the servicer is. So when it says we're doing an assignment of servicing, all right, we're changing servicers, that's legal. They can do that every day.
Right. But what is not legal is for them to create an assignment for that security instrument long after they've sold those payment obligations.
Again, you have to ask yourself, what is it that they're assigning? Because, again, they're going, if you read many of these say, together with the note, principal, and interest. Well, wait a minute, how can you assign the note? You can't assign the note. The note is not eligible for negotiation. The payment intangible obligation is owned by another party. So this security, beneficial interest in a security deed is a nullity. Okay, so I'm going to sign this document. I mean, Mickey Mouse could have signed the document.
Right. And they wrap it
It's a nullity.
They wrap it in legalese so it sounds official, and people buy off on that.
Correct.
Right.
That's what we must question.
Right. Now, before we leave today, can you discuss with us real briefly the highlighted prospectus and what that brings to the people when they could download that and print it?
Not a problem. And just for your own information, you can send out a copy of that highlighted prospectus, the instructions that go with it, and the index that I've created.
Yeah.
To anybody that asks for it. I have no problem at all.
I've actually, Joe, I've uploaded it onto the website, and so they can just link it. They can just click the link.
What the prospectus, the highlighted prospectus is for educational purposes. Because everybody wants to know who are the parties to these transactions and how do they fit in with my loan.
Right.
All right? Now, what you have to understand is that many of these parties, all right, really, you don't, while they pertain to the transactions, all right, you never contracted with them, all right?
Correct.
Because in order for a REMIC to be bankruptcy remote, they have to have a minimum of 2 transactions out. Now, one of the things that I've done is I've created my index. So basically, if they print out the entire prospectus and they would hole punch it and put it into a 4-inch D-ring binder, all right, and then they would get themselves a pack of the signature tabs.
Right.
And then they're going to get themselves a Sharpie. So now they have the highlighted prospectus on one hand, and then the index on the other, and they're going to go down, and it's going to say P1, basic information to investor.
Right.
P3, table of contents. So they're going to take with the Sharpie, and they're going to write in on these tabs, and then go in from descending order from the top down. Once they go through that entire index that I've created and have it with the binder, they have a completely highlighted and indexed 424B5 prospectus. The prospectus gives information such as who is the trustee? What is a trustee? Okay? What is a seller and depositor? It talks about conveyance of loans. What is a conveyance? A sale is a conveyance, but a conveyance is not necessarily a sale. The difference is that consideration. So within this prospectus, it's an educational tool that will give you information as to all of the different items that you would want information on, as far as what is a mortgage pool? What is mortgage insurance? In regards to certain tax matters, the prospectus covers this. Now, while this is not anybody's specific prospectus for their trust, this is a boilerplate template that has a lot of good information. So when you want to understand what are prohibited transactions, it'll tell you. When you want to know what is a closing date and how does it pertain, it will show you.
Right. So this is basically an example prospectus of a securitization.
No prospectus. However, this is just one that I was doing for an attorney.
Right.
He was going to court and he wanted to see, I need to see everything. And so it was a countrywide. Because Countrywide was one of the top producers of all these loans, it made sense to go to a countrywide trust for me.
Right.
So when we go through it, again, everything is already highlighted. So as an educational tool, you don't have to read all 346 pages. I've already done it. But if you want to learn about tranches, what is a tranche? What does it do? When they're talking about modifications, what can be done, what can't be done. The prospectus covers that.
Right.
And that's something very important. Once they have just a general understanding, all right, they'll be much more informative as to what's going on. What is a NIM insure? Again, many of these items do not pertain to the homeowner specifically, and they pertain to the trust, but these are all relevant information for the homeowner and for their attorney to know. If you're going to use an attorney, I, as a homeowner, would want to be as well informed as possible as to what the attorney was doing and what his arguments were.
Right, and truly, this is really one of the most difficult hills for homeowners, because many attorneys didn't know this stuff, and they're having to learn this too.
Still don't.
And still don't. And trying to use this information in pleadings in a manner that will get a win or get the, some kind of leverage for the owner is very difficult.
Well, if you read a large number of the pleadings are generic. They talk about John Doe's loan was sold to Freddie Mac or Fannie Mae or to Seawalt 2005-J Trust. And they're not specific. What are you talking about when you're talking about John Doe's loan? Are you talking about the tangible promissory note?
And see, Joe, that tangible, intangible, if of anything that we've really talked about on the show, I've gotten a lot of good feedback about that concept, because it really has helped clarify this fog of, like you just said, they sold the note. No, they didn't actually. They sold the payment stream of that note.
Oh, did they sell the intangible note? Remember, there is more than one note. All right? And this is why many times...
Clarify that. What do you mean there's more than one note? Say that again.
There is what's called an authoritative copy. All right? When the documents are scanned in through the scanning imaging system, all right, an authoritative copy is made. The authoritative copy is supposed to be it would be similar to the original tangible note. However, the problem is that because this pertains to real estate, right, there are no electronic laws of commerce.
Right.
Why we have statute of fraud.
Right.
Because everything must be tangible. So, if you, I've got PowerPoints of MERS where they talk about, and as a matter of fact, L.B. Campbell has written a great paper called Digging the Pope, and also Parallel Universe.
Yes, I have both.
That compares the tangible and intangible world.
Right.
I have another discussion, just on that, and I believe James did a wonderful show on the intangible and tangible.
And so basically, Joe, what I just heard you say, this is what I think I heard you say, is that by dealing in an electronic world, the intangible world, on real estate, it's basically violating the statute of frauds.
Yeah, you're supposed to have everything is supposed to be in writing. If you look at California, California has its own statute of fraud, where what items are needed in order to have a transaction? You need to have a promissory note, you need to have consideration, and you need to have a memorandum or written statement regarding the conveyance of the property in order to do a real estate transaction. Correct?
Correct.
Okay, so now MERS, in many of their assignments, all right, these are all in the electronic world.
Right.
So if we're saying that it has to be in writing, they're doing an electronic copy. Right.
Which violates, like you started with, 15 U.S.C. 7003.
Correct.
Yep. Oh my goodness. Oh, this is okay.
And you have to understand, for a long time there's been a misconception that what the MERS milestone report was actually doing. The MERS milestone report reflects the intangible, not the tangible.
Right, because it's just whatever happened in MERS, which is the intangible piece.
It's what happened within MERS. All right?
Right.
And private notice is not the same as giving public notice, constructive notice to the world.
Exactly. And I'm telling you, it really struck me. I've live streamed the Oregon Supreme Court of Appeals. They were hearing, MERS had appealed the decision of Oregon to not allow MERS to foreclose. And they had that an hour and whatever, few minute session live streamed. So I've live streamed it. It's on, our channel. And you can watch it, and it's fascinating because one of the first questions one of the Supreme Court justices asked the MERS attorney was, he kept referring to it as transfers, and she was saying, well, it has to be an assignment. So now, better understanding the tangible, intangible worlds, because at the time I didn't have nearly as good of an understanding, that was just 2 weeks ago, is that she was struggling to find out from him, why are you keep calling these transfers? Because it's required to be an assignment. And he's going back into MERS saying, no, it's just a transfer. And that would be the MERS milestone, right?
Right. Again, you have to understand, what are they talking about? Are you talking about the electronic intangible, or are we talking about the tangible documents? So,
I think personally that this exposure and your charts, I'm going to load all these charts up, I promise again, so that you can, because he's got them now for Fannie Mae requirement with MERS. Now you have one without MERS. Let's take a real quick look at that.
Sure. Give me 1 second.
And then while he's getting ready, he's also sent me for Freddie Mac, the two with and without MERS,
correct,
for Ginnie Mae,
right,
and then some other RMBS flow charts.
Right, because you have to understand, I mean, Fannie Mae was the original, and then 1938, I believe, and then Freddie Mac was created in 1970. All right, Freddie Mac has always been a private. So even though they're government-sponsored enterprises, all right, they still have board of directors, Freddie and Fannie. So Ginnie Mae is the only true government-sponsored enterprise that is backed, by the taxpayers. Freddie and Fannie, they are private. So if there is a default on the intangible payment obligation, Fannie Mae is liable for that.
And that's why they go to Congress for another $39 billion.
Mm-hmm. But again, it is a for-profit company.
Right. Where the profits are privatized and the risks are socialized. In other words, we get the risk, they get the money.
Yes, because they're private, again, they don't have to show all their documentation.
Well, it's just like all the other federal agencies, Federal Reserve, FDIC. I mean, now they are on the hook for anything and everything the banks do, which means you and I are actually backstopping all that.
Right. Now, if you look at the Fannie Mae without MERS, one of the differences is this. An assignment listing Fannie Mae as assignee is created in recordable form, but is not actually recorded.
So where is it? Do they just hold that in hand or something?
It stays in the collateral file. It stays in the file of documents, the paper documents.
And so when does that ever get recorded?
No.
Oh, they just hold it.
They just hold it. And again, it's described in Section 8.2 in the Fannie Mae requirements for custodians. I've got all the manuals.
Right.
And the same thing with Freddie Mac. We described where it says in what manual.
That's fabulous.
And again, you would find this document. It is an actual document. You would find it in the collateral file for John Doe, because there still is a paper file that must be kept. But as you know, just as signing a loan, you have from 60 to 80 documents. All right? In the actual collateral file, because you have a collateral file and a credit file, right, you can have anywhere from 200 to 300 documents of tangible documents. All right? Because, again, everything must be in writing. So you've got the master title insurance policy. You have every document that is supposed to be in this collateral file. And this assignment is listed in there. It's never recorded, but it's made. It's made out to Fannie Mae. So when the default on the intangible happens, again, they will do an assignment to the servicer, and the servicer will act as an agent for Fannie Mae or Freddie Mac, and they will start the foreclosure proceedings. They will say, Fannie Mae owns your loan.
Right.
Again, Fannie Mae is not recorded into public. Fannie Mae is not listed as beneficiary or as mortgagee. But yet they say, Fannie Mae owns your loan, and we're, or else if there was a sale, they'll say, Fannie Mae did a credit bid. No, they didn't. It was a set-off. All right? They're just showing their books. They had to put something on their books.
So even that is not legal, according to the way it's supposed to work.
Again, you have to look at what did they buy.
Right, because my understanding, people have talked about these auctions when the bank, quote, takes it back, that they do a credit bid, but the only person or entity allowed to do the credit bid is the actual holder of the note.
Again, holder of what note?
Right.
Talking about all right, again, many times, like in Countrywide's case, they were custodian of documents. So are you going to get into holder, meaning simple possession of a personal property versus legal possession with rights? All right? Because you can have the mailman be the holder of the note.
Exactly. They can physically hold it, but they don't have any legal rights to it.
Right. Now, yeah, legal ownership with rights is completely different because
right.
I'll use an example. I'll use me as an example. Okay, so I've had Countrywide. So Countrywide, all right, sold the payment intangible to Fannie Mae. All right, now,
yes.
Upon default, all right, Fannie Mae says, okay, we have, I have the note. I'm Bank of America. Well, what do you have? Because while Bank of America was successor interest to Countrywide Financial because they did the portfolio buyout in 2008, Bank of America acquired the personal assets of Countrywide Bank. Those personal assets included documents pertaining to be a promissory note with my name on it. Again, that promissory note is a worthless piece of paper.
Right.
Because the payment intangible obligation had been stripped, and that paper tangible note was no longer eligible for any negotiation. So while, yes, they may have simple possession of personal property that they have acquired,
right,
does not give them legal possession with rights.
It's all about the words. I tell you, the description, you've really helped clarify the fact, it's not just physically holding the piece of paper, like you said, simple rights of possession, but the legal rights as a, would you say beneficiary of the note? How would you say that?
All right, say it one more time.
You say it one more time.
Okay. When Bank of America took over Countrywide,
right.
Okay, Bank of America became owner, okay, by successor of the personal property of Countrywide.
The pieces of paper in their files.
Correct. And they were just pieces of paper. They were personal property of Countrywide. Yes.
Right.
Countrywide was the owner. Okay, now, those pieces of paper, all right, that were promissory notes, okay,
Right.
all right, that's what they are. They're pieces of paper. That's personal property. Now, if the payment intangible obligation had been ripped out, such as in my case,
Right.
that piece of paper was now a worthless piece of paper. And the security instrument, which evidence the conditions in which to collect payment, is a nullity, because if you go back to Carpenter versus Logan, a mortgage cannot survive a moment without the debt.
So
Well, if I've sold the debt,
right.
then there is nothing for the security instrument to attach itself to.
Right.
So the security instrument becomes a nullity.
Right.
So claiming that you are a holder, what are you holding? Well, I'm holding the note. What note?
Right. You sold that obligation.
Right. If you've sold the obligation, right, you cannot collect twice on the obligation.
The banks are collecting repeatedly, trust me.
Correct.
Yeah. Illegally.
Attempting.
Yeah.
Right. So what we have to do is come forth with the correct argument. All right. So depending on what state you're in, you're going to argue it according to your state statutes.
Right.
Again, that's one thing. That's what, MCI does. We attack it statutorily.
Right.
No guesses.
So that basically a judge, if you will, would be forced into making the correct decision.
And if not, then you would take it to the appellate court. You always want to prepare, for the appeal. Always.
Right. Right. And my
Prepare for the
understanding,
appeal.
from others is that getting justice in the lower courts is very difficult, but on appeal, like in the Ohio last update Friday, there were several decisions that have been overturned in the Court of Appeals in favor of homeowners. That homeowners can get better justice in the appeal process. But again, it has to be the right argument based with the right statutes in that state.
Correct. Because there is so much bad case law, yes, you're going to have the banks that are going to cite citation after citation. And this is why when you state your argument, all right, if you're going to state it, all right, state it correctly, use the correct statutes. Use their documents. We don't need to create any documents. The documents are there. We need to look at the documents and
Right.
see, what does the document say.
Right.
The document says, example, in Covenant 16, all right, this, it's under governing laws, rules of severability.
Right.
Government shall be governed by federal law, state law,
Right.
to local laws of jurisdiction in which this property resides in.
Right. Joe, it's been really great.
Thank you.
We've run really long. I'm going to have to cut you off. But the fact is, people, if you have questions, don't be afraid to email them to me or email them to Joe. I'll pass them on to Joe, and then he can contact you directly. I'm sure his email box is getting as stuffed as mine. We thank you so much for sharing. And the more clarity that people have in this smokescreen that has been created intentionally by the banks for their personal profits, and it's not just the bank themselves, but the CEOs. It's the leaders of the bank that profit personally. The best way to rob a bank is to own one, and they will throw the bank under the bus in a heartbeat if it means they keep their billions. So we thank you so much, Joe, and we thank you, audience and viewers. Please pass this on. You can share these individual shows. There's a little share button, and you can just send them out to your Facebook or to your friends. Please, and I'm linking them into the website. Let's get the word out. The people must understand the level of fraud, and the fact is we can grasp it and we can fight back. So this is CJ Holmes, founder of Homeowners for Justice, signing off for today. Thanks, Joe, and we'll talk to you soon.
Thank you.